My folder. Here.
Who is sitting with Ms. Feely down in front of Judge Emerson?
Natalie Fiacco.
Okay. And do we know who's with Mr. Jordan?
I think it's Christian Atkins, I think.
Okay.
Thank you.
Don't worry. One moment.
Yeah, there's jurors on a MARTA bus that had an unruly passenger that had to be removed. That was his scary dilemma. Think of that more as airplanes than buses where that happens. I don't know. But that is an alternate. Sure. Oh, we're down to one juror.
Like,
Miss May herself. Yeah, absolutely. Please do. Pay for yourself.
yeah.
So yeah, but is it 1D? Judge, are they in 1D with Judge?
Yes, 1D, Delta.
Okay, so then I'm not sure what time they're getting started down there, but you should be able to see if somebody's opening. Yeah, perfect. Yeah, that's totally fine. Thank you.
Hey, Ms. Fuse, can you hear us?
Yes, good morning.
Welcome back.
Thank you.
Appreciate you being here. I think we have a plea rather than a trial this morning, but we'll need to get Mr. Dixon, that's the defendant, out here. We'll need to get the prosecutors back in here. Do you have the style of the case? I don't know if you were roped in here because they couldn't find someone and you're not quite sure what's going to happen.
Is it State of Georgia versus DeMarcus Dixon?
It is.
Okay, and I have the, is it the indictment number?
Yeah, that ends in 604.
Yes.
Great, you've got everything you need.
Okay, thank you.
Sure.
one B. Okay.
Okay. Ah, good. Yeah, that probably subpoenas had said 8D. Yeah, that may happen.
Seriously.
Sorry, Judge.
No problem. If you need time to get folks here, one, they can join the Zoom, but two, we could take the plea, as in I accept the plea, and then we could do sentencing later, whether it's today or sometime this week. It can be broken into two pieces. I don't want to deprive either of the victims of an opportunity to be heard, if that's what you're concerned about.
Thank you, Judge, and sorry for interrupting. That's what I was going to recommend. One of our victims is already in the courthouse. The other anticipates she can get here by 10:30. So if we want to take the plea, and then we can handle sentencing later this morning, I believe.
Great. If we can do it this morning, then we'll keep Ms. Fuse on the Zoom. I'll hear from Ms. Wood in just a second on that. But then we're not going to keep the jurors here. I don't want to release the jurors until I accept the guilty plea, and I'll let him know he doesn't get to withdraw it just because he doesn't like the sentence. I am bound, of course, by the statutory maximums, et cetera, and I'll be very much guided by the two polls that are set by the recommendations. Is that, and I'll explain all this to Mr. Dixon. Does that work for you, Ms. Wood? Okay. All right. Then let's bring Mr. Dixon out, please. So one is here and the other is making her way here.
Yes, Judge.
Great. If you could move the microphone towards you, it'll help the court reporter. It can be at the podium. It can also be seated because our court reporter is not here. Do you have a preference, Ms. Wood?
I don't.
Okay, we'll just do it right there.
Yeah, you qualify.
All right, let's get started. We're going to get on the record in, no, let's not get
Sorry.
started. Okay,
If I could just pull up a colloquy and grab a copy of the indictment, we should be ready.
here you go.
Thank you. Okay, thank you, Judge.
Sure. Let's get on the record now. Excuse me. It is Wednesday, the 19th of April, and we're here on State versus DeMarcus Dixon. It's indictment 22 SC 184604. Mr. Dixon is here in court with his lawyer, Ms. Wood. Mr. Shapiro and Ms. Lugo represent the state for this prosecution. On Monday, we picked a jury in the case. 13 of our 14 jurors are sitting in a jury room right now. We have one juror who was waylaid because of an issue on a MARTA bus, but who will be here momentarily. I was prepared to engage the lawyers and Mr. Dixon with a couple of pretrial matters to include a motion in limine that Ms. Wood had filed in connection with the state's expert. But Ms. Wood told me, Mr. Dixon, that you, upon further reflection, prayer, consultation, whatever it might be, have decided that you want to enter what we call a non-negotiated plea in your case. Is that correct?
Yes.
Okay. And you're going to be asked a bunch of questions if we go forward. You'll need to make sure you answer out loud. You're welcome to nod your head or shake your head, but you'll have to verbalize it as well because the court reporter is going to need to take that down. Okay.
Okay.
And the court reporter is virtual. She's actually very real, but she's here virtually. So she's going to hear you through that microphone rather than from sitting right in front of me. Mr. Dixon, A plea is one way to resolve the case, and that is your right to resolve the case by way of a plea. I want you to understand how the process is going to work this morning. We're going to break it into two pieces. The first piece is going to be Mr. Shapiro explaining to you all the rights you have as a criminal defendant and the rights that you'll be giving up if you plead guilty rather than go to trial. I may hear a little bit from Mr. Shapiro about what the state's recommendation is and what the factual basis is of the plea. In other words, the evidence that the state thinks they could share with the jury. I will hear from Ms. Wood and I'll hear from you. But the first part, we're not going to do sentencing. I'll accept your plea or I won't. And if I find that you understand what your rights are and you are intelligently and voluntarily giving up those rights, then I'll accept your guilty plea and we'll be done with the guilt innocence part. You will be adjudicated guilty of the crimes in the indictment. Then we're going to take a brief break. We'll reconvene this morning, but the two young ladies who are the alleged victims in this case have a right to talk to me in your presence about what they think should happen. And they may say, Judge, be lenient. They may say, Judge, Mr. Dixon is the devil. They're entitled to say whatever they're going to say. And I will listen to that and I will factor that into what I'm going to do. But that's going to be part two of the hearing later this morning. And Ms. Wood will be there by your side the whole time. And that's when we'll talk about sentencing. I just need you to understand that we're doing it a little bit differently this morning because I need to give those two individuals, the alleged victims in this case, a chance to get here to court. Does that make sense?
Mm-hmm. Yes.
Yes? Okay. So again, this first part is just going to be, do I accept your plea? And I'm not going to tell you, and here's what your sentence is. In fact, Ms. Wood's not going to advocate on your behalf about, Judge, the state's asking for too much. Here are reasons why you should give Mr. Dixon less. She will do that. She's going to do that during part two, which will probably be in about an hour. Okay?
Okay.
If you have any questions at any time about what's going on, you need to let Ms. Wood know or me or both of us so we can pause and one or both of us can try to answer your questions. Will you let me know if there's anything you don't understand or just isn't making sense to you?
Yes.
Great. I'm relying on you to do that. Mr. Shapiro, when you're ready.
Mr. Dixon, would you please raise your right hand? Swear or affirm that any statements or testimony you shall give in the matter currently before the court shall be the truth, the whole truth, or nothing but the truth?
Yes.
Thank you. You can lower your hand. Would you please state your true and correct legal name for the record?
DeMarcus Dixon.
And are you at this time taking or under the influence of any medications, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not taken or been given today?
No, sir.
So, Mr. Dixon, you paused a little bit. Do you take medication for allergies, asthma, depression?
I had depression medication, but I haven't really taken it recently.
Okay. How long ago? When's the last time you took medication for depression?
So 2021.
Okay. So a while ago.
Yeah.
Did you stop because the doctor said it was okay, or it was
Just moved.
you moved and just you weren't taking it?
Mhm.
Okay. Does the fact that you are not taking that depression medication right now make it hard for you to understand what we're talking about?
No.
Okay.
Mr. Dixon, how old are you?
29.
And how far did you go in school?
2 years of college.
So you're able to read, write, and understand the English language?
Yes.
Mr. Dixon, do you understand that in this indictment, you have been charged with the following offenses: aggravated battery, 2 counts of aggravated assault with a deadly weapon, 2 counts of terroristic threats and acts, 1 count of cruelty to children in the first degree, and 2 counts of possession of a firearm during the commission of a felony.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to those charges?
Yes.
And do you understand that if you were to plead not guilty or were to remain silent and refuse to enter any plea at all, then the state would be required to prove these charges against you at a jury trial?
Yes.
Have you had enough time to discuss the facts of these charges with your attorney?
Yes.
And would you like more time to discuss the case with your attorney?
So you're good.
I'm good.
You're good.
Yeah, I'm
Because
good.
if you need to chat with Ms. Woodmore, you can. You'll get to talk with her again after this first part, the guilt innocence part, because we'll be waiting on those 2 individuals to show up. But if you need time right now, then you should let me know that and we'll give you time to talk more. You good or you want to talk more?
I'm good.
You're good. Okay. If that changes, tell me, because you can always have a little conference with her, but we'll keep going for right now.
Okay.
And Mr. Dixon, are you satisfied with the services that your attorneys provided for you?
Yes.
Okay. Ms. Dixon, or excuse me, Ms. Wood, are we waiving a reading of the indictment for purposes of the plea?
So waived.
And are we waiving any and all defects in the indictment for purposes of the plea?
We do.
Mr. Dixon, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading guilty today?
This is.
Yes.
Do you understand that by pleading guilty, you are entering what's called a non-negotiated plea, and that the state may recommend a sentence to the court without your having agreed to it in advance?
Yes.
Now, are you aware that the state's recommendation to the court is going to be a sentence of 25 years to serve 15 in custody with the balance on probation?
And we will ask for something different.
Can you repeat that for me?
Certainly, Judge. The state is going to be making a recommendation of 25 years to serve 15 in custody with the balance on probation.
Okay. So, Mr. Dixon, here's what I'm understanding is going to happen. Not right now, because we're not going to talk about sentencing, but in a little bit, when we get the other two folks here, Mr. Shapiro is going to argue that the sentence I ought to give you should be 15 years in custody, followed by 10 years on probation. That doesn't bind me. I don't have to give you that sentence. I could give you more. I could give you less. And the very first thing I mentioned to you is this is a non-negotiated plea. That says to me that Ms. Wood is going to argue for a lower sentence. And I'm going to ask her what that is before we break for the first part of the hearing, just so I know what the two positions are. The state is saying 15 to serve, and Ms. Wood's going to say X, whatever it is. So I can already be thinking about it. But neither one of those recommendations ultimately controls what I do. Do you understand that?
Yes.
Okay.
Mr. Dixon, have you discussed what the state's recommendation to the court is going to be with your attorney?
Yes.
And do you understand that, as the judge just said, the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence for each charge?
Yes.
And do you understand that if you enter a non-negotiated plea, you do not have a right to withdraw your plea once the court enters its sentence?
Yes.
And do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Mr. Dixon, are you currently on probation or parole?
No.
And do you understand that while on probation, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes.
Do you understand that while on probation, you must follow any of the special conditions of probation that the court imposes?
Yes.
Do you understand that if you fail to follow any special conditions of your probation, then you could be subject to a revocation of that probation for the balance of your sentence?
Yes.
Do you understand that while on probation, you're not allowed to possess or use a firearm?
Yes.
Are you a United States citizen, Mr. Dixon?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm in the future?
Yes.
Do you understand that doing so could result in new criminal charges for which you would face a sentence between 1 and 5 years?
Yes.
Do you also understand that by pleading guilty to a felony, you also may not use a firearm in the commission of a crime in the future?
Yes.
Do you understand that if you were in the future to use a firearm in the commission of a crime, you would face a consecutive custodial sentence, which means a sentence in addition to the underlying crime itself?
Yes.
Mr. Dixon, do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes. Can you repeat the question?
Sure, and I'll go one at a time.
Right. And Mr. Dixon, so that you're dialed into this, in my mind, this is some of the most important questions Mr. Shapiro is going to be asking you, because he's sharing with you. I'm going to give you one example. You have the right to go to trial if you want to, but you're telling me, you know what, I don't really want to go to trial. I want to enter a plea instead. And so Mr. Shapiro is letting you know that if you enter a guilty plea, this right that you have to go to trial, to have Ms. Wood be your lawyer at that trial, you're giving up those rights because you're pleading guilty, and a jury isn't going to be deciding guilt or innocence. You're going to be telling me, you know what, I did it and I want to face the punishment, and Ms. Wood's going to argue for me what that punishment should be. Does that make sense?
Yes.
Okay. You seem like it doesn't make sense. Tell me what's confusing you.
The appeal part.
Okay, well, we'll get to the appeal because you do have a right to an appeal. Your appeal rights are reduced when you have a guilty plea. If you had a trial, then a lawyer working on your behalf could say, oh, the prosecutor made this mistake, the judge made that mistake, your own lawyer made some mistakes. If you enter a guilty plea, there still can be an appeal, but the universe of what can be challenged on appeal is smaller because there are fewer moving parts. No witnesses testified, so there was no hearsay. No exhibits were admitted, so there were no mistakes in admitting the exhibits, that kind of thing. It's whether you understood your rights, whether I entered a legal sentence. If I sentence you to 1 million years, that's an illegal sentence because the maximum, he's already told you, is these numbers that end in 20, and 1 million is too big. So there's certain things you can appeal if you enter a guilty plea, but there's a whole bunch of stuff that's now off the table because it didn't come up because there wasn't a trial. Does that make more sense?
Yes.
Okay, let's keep going.
All right, so Mr. Dixon, with that explanation from the court, do you understand that by pleading guilty, you are giving up the right to a trial by jury?
Yes.
And do you understand that you're giving up the right to remain silent?
Yes.
Do you understand that you're giving up the right to confront witnesses against you?
Yes.
Do you understand that you're giving up the right to the assistance of counsel?
What I mean?
I'm sorry?
What's the assistance of counsel?
Do you understand that you're giving up the right to have Ms. Wood assist you at a trial?
Yes, yes.
You're not giving her up for this. She's going to be with you the whole time during the plea, but because there's no trial, then you don't have a lawyer helping you with the trial. It's kind of silly to say that, but we need to explain that if you went to trial, you'd have a lawyer helping you the whole time. Okay?
Yes.
Do you understand that you're giving up the right to the presumption of innocence?
Yes.
And do you understand that, as the judge just explained, you're giving up certain appeal rights if you were convicted of these charges at a trial?
Yes.
Is it your decision to waive all the rights I just mentioned, which means not to use them, and to enter a plea of guilty today?
We'll do the second part of this. So you just need to say yes.
Yes. Yes.
Mr. Dixon, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
And is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Dixon, in indictment number 22 SC 184604, how do you plead to count 1, aggravated battery?
Guilty.
How do you plead to count 2, aggravated assault with a deadly weapon?
Guilty.
How do you plead to count 3, aggravated assault with a deadly weapon?
So that way, that was the offer before trial and we're here at trial. So all counts are on the table.
Huh?
So
You get it?
So, Mr. Dixon, normally, I appreciate that Mr. Shapiro is being thorough here. Normally, what the prosecutor asks is, how do you plead to the counts in the indictment? And you just say guilty once because you're pleading to all the counts. Mr. Shapiro, because this was almost a trial, we got that close, is wanting to be sure that you are pleading guilty to each of the counts. That sentence that he's going to recommend covers all the counts. So he's not going to, Mr. Shapiro is not going to be asking for, we want 15 on this one and 19 on that one and 11 on the other one. The total recommendation from the state across all those counts added together is the 15 years to serve.
and then we'll ask for what we're asking for. So it's not, the judge said it's all one thing. He's just going to.
So I give you a sentence for each count, but what I'm making this up for Mr. Shapiro, but what I suspect he's going to say when we get to part 2 of the hearing, Judge, we think that Mr. Dixon should serve 15 years on count 1, 15 years on count 2, 15 years on count 3, but those should run, and the word he'll use is concurrently, meaning at the same time. So that's not 45 years, it's 15 years on each of those, but they're all running at the same time. And you've already served however much time you've served of that sentence. So that 15 years is, if you add up all the pieces, it's going to be 15 years. But you're charged with each of these counts, and the state has not said to me, we're dismissing some and going forward with others. So either you are pleading guilty to this collection of activity that involves, as I understand it, you supposedly firing a shot into a car and it hit one young lady and it didn't hit the other lady. And that's sort of the substance of what we're working through. So Mr. Shapiro is simply confirming that you're pleading guilty to each count, because if you say, well, I'm not pleading guilty to counts 4 and 5, okay, then let's bring the jury in and let's go to trial on counts 4 and 5. We can try some of the counts. Generally, we try all the counts or none of the counts. My understanding was you were pleading to all of the counts. So if you need to chat with Ms. Wood,
Chat with Wood.
sure. Are we all right? You have your supervisory team here. Where'd your,
I'm never all right without my supervisor.
okay. Whenever Macaulay walks in, I get nervous.
Hey, I'm amazed they let me go anywhere by myself.
Yeah. Is Temperance here? Was that one of the people?
She was, Judge.
I don't know. I just know which one was Macaulay. That's too bad. All right, Ms. Fuse, are you ready for us to pick back up?
Yes.
Great. We took a break so that Mr. Dixon could speak with Ms. Wood. We were at the point of the plea conversation during which Mr. Shapiro was asking Mr. Dixon how he pleads, guilty or not guilty, to each of the counts. And Mr. Dixon had grown a little concerned, like, wait a minute, there's so many counts. Am I going to end up getting 15 years on each one? And do they add up? So we had a little bit of a conversation about that. Mr. Dixon, are you comfortable proceeding?
Yes.
Do you have any questions about anything we were discussing?
No.
Ms. Wood cleared up your concern?
Yes.
All right. Mr. Shapiro, why don't you start at the top again and make sure we get through it all?
Have to, Judge. Mr. Dixon, as to count 1, aggravated battery, how do you plead?
Yes.
How do you plead as to count 2, aggravated assault with a deadly weapon?
Guilty.
How do you plead as to count 3, aggravated assault with a deadly weapon?
Guilty.
How do you plead as to count 4, terroristic threats and acts?
Guilty.
How do you plead as to count 5, terroristic threats and acts?
Guilty.
How do you plead as to count 6, cruelty to children in the first degree?
Guilty.
How do you plead to count 7, possession of a firearm during the commission of a felony?
Guilty.
How do you plead as to count 8, possession of a firearm during the commission of a felony?
Guilty.
Mr. Dixon, do you understand that, or excuse me, is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of this guilty plea or any other constitutional aspect of the guilty plea, you must do so by filing what's called a habeas corpus petition?
Yes.
And do you understand that because these are felony charges that you would have only 4 years from today to file a habeas corpus petition?
Yes.
Thank you, Mr. Dixon. And Judge, I would request that the state be permitted to elaborate on the factual basis for purposes of sentencing, however, to provide a very brief factual basis.
So it's clear. I want Mr. Dixon to make sure he understands, because you're going to sort of do it twice. Right now, Mr. Dixon, Mr. Shapiro is going to give me just sort of a thumbnail sketch of what he thinks the proof would be at trial, what the evidence would be. I have to find that there's actually enough evidence for a jury to convict you. If Mr. Shapiro were to say, you know what, it was all guesswork. The police saw some guy running away in a black robe. That could have been you. That could have been me. And that's all the evidence they have. I might say, I'm not accepting your plea, because that's not enough evidence. So I'm going to hear a little bit about what the evidence is. When we get back together later this morning, I suspect I'm going to hear more, maybe more specific details about the injuries and things like that. I don't need to hear all that to accept your plea, but I am allowed to hear that in support of the state's argument, in the same way that Ms. Wood may tell me things about your childhood that in some ways have nothing to do with what happened in this case, but they have a whole lot to do with what you've been through and maybe your own struggles. Like you and I had a brief exchange about depression, and that may be something Ms. Wood shares with me. That doesn't have to do with, did you commit these crimes? But I want to hear about that when we talk about sentencing. Okay.
Yes.
All right, Mr. Shapiro.
Your Honor, on July 5th of 2022, officers with the Atlanta Police Department responded to a person shot call at Grady Hospital in the trauma center. They made contact with the victim of that shooting, 16-year-old Janiyah Jones. She was transported to Grady by ambulance with a gunshot wound to the chin and a bullet lodged in her neck. Also present at the hospital was a witness to the shooting, Miss Relia Edwards Holland. She is 18 years of age. Investigators spoke with Miss Holland Edwards, who identified the shooter.
Is it Holland Edwards or Edwards Holland?
Edwards Holland.
Because I've heard you said it two different ways. I just want to
I'm sorry.
make sure I get it right. Edwards Holland? Okay.
Miss Edwards Holland identified the shooter as her then boyfriend, DeMarcus Dixon, stating that he arrived at the scene, which was 2380 Metropolitan Parkway in Fulton County, in a white SUV, and fired a single shot into her vehicle, which struck Miss Jones, who was the passenger in that vehicle. Officers were able, based on the information that they obtained from Miss Edwards Holland, to pull a driver's license photo for Mr. Dixon. It was shown to both Miss Edwards Holland and Miss Jones while at Grady Memorial. Both of them identified Mr. Dixon as the shooter. Investigators also conducted a second interview on July 10th of 2022, in which once again, both victims were shown a single photo of the defendant, Mr. Dixon, whom they identified as the shooter. Warrants at that point were obtained for Mr. Dixon's arrest, and he was apprehended and taken into custody on July 12th of 2022.
Got it. Tell me what the evidence for the terroristic threats is.
Judge, in statements to investigators, both of the victims recalled that before the shot was fired, Mr. Dixon yelled out, "You think I won't kill you, bitch."
So it was contemporaneous with the shooting. It wasn't the day before. There was an argument between Ms. Edwards Holland and Mr. Dixon, but it was the yelling and then the shot fired.
Immediately before the shot was fired, Judge.
Okay, and the cruelty to children is really predicated on the fact that Ms. Jones was a minor at the time.
That's correct, Judge.
Okay, it's not a separate, there wasn't an infant in Mr. Dixon's car or in the car that Ms. Edwards Holland was driving.
It's based on the injury to Ms. Jones.
Okay, got it. Well, we can talk about what might merge and might not when we get to sentencing, but I appreciate all that. Ms. Wood, is there anything you want to add at this juncture?
Not at this juncture, Judge.
What is it that you, if you have a sentence in mind that you are intending to recommend so that Mr. Dixon can hear you say, this is what we're advocating for?
We are intending to advocate for the state's original offer, which was 20-8.
Okay, got it. Mr. Dixon, do you have any questions about what we've talked about so far?
No.
Okay. We don't need to work through it right now, but I would like the state and Ms. Wood to discuss what we might do with Mr. Dixon's open drug case and his 2 CP cases, so that maybe we're resolving all 4 matters at once. In light of the likely outcome, we know the outcome here, there's going to be a sentence, and it looks like the floor from the defense perspective is 8 years. So I'd like you all to confer about that. You and I, Mr. Dixon, need to talk a little bit more though. Based on what Mr. Shapiro said to me, I find that there is a factual basis for your plea. And what I mean by that is that if we brought these jurors in and now they're all here, we've got all 14, and the state was able to present that evidence that you were in that white SUV and said those things, and the 2 young ladies probably will identify you in court, but they at least identified you through the driver's license photo, made the statements that they made, that a jury could say that you're guilty of those crimes. Would a jury do that? I don't know. I'm guessing Ms. Wood has given you her thoughts about the strengths and the weaknesses of the state's case. I don't need to make that decision now. I just am concluding that based on that evidence, a jury could find you guilty. And so I will accept your plea. I also find that your plea is what we call knowing and voluntary. I want to talk about both those words. A voluntary plea is a plea that a defendant makes because he's decided, this is what I want to do. I don't want to go to trial. It is a better outcome for me to say I did these things, let my lawyer argue for leniency or mercy or something, than to go to trial, have these young ladies come in here, testify, and then it might be a very different outcome. Does that describe your situation, that you're not particularly excited about either entering a plea or going to trial, but the thing you want to do is enter the plea?
Yes.
Okay. A knowing plea means that you've understood after conversations with your lawyer and you and me talking some, that you understand the rights that you had, the right to trial, have a lawyer help you with the trial, call witnesses, cross-examine witnesses, all those things. You understand that you have those rights, but that if you plead guilty, you're saying no thank you to those rights, and you're taking the certainty of a guilty plea with this sentencing range that the lawyers have described. Doesn't bind me, but at least you know the most the state's asking for and that what your lawyer will be asking for. So do you feel like you understand what we're doing right now?
Yes.
Okay, then I'm accepting your plea, and we will get back together. I'm guessing, do you have an ETA?
I can get one, Judge.
Okay.
immediately, But
All right.
10:30 was the last ETA. I was
Okay.
given.
So in about 45 minutes, we're going to talk about sentencing. We're not going to talk about, wait a minute, what's the guilty plea? I've accepted your guilty plea. And in fact, let me ask you another. Let's actually do it in writing. You've got the indictment right there. If you could, we'll revise all the signatures. So we'll use a different signature block. Mr. Dixon, I'm asking you to sign the indictment again. And instead of a not guilty plea, this is indicating your guilty plea in this case.
Sign right there. Thank you.
So we'll bring you back out here as soon as the state is ready to go. It'll be this morning and we'll talk more.
Thank you, Judge.
Thank you.
Judge.
Thank you, sir. So when Ms. Wood comes back out, I'm gonna bring the jurors out and excuse them.
Judge, we approach.
Sure. Do you need to approach or can you just tell me?
I think we can just announce it. I just said, we would ask that the jurors not be excused until the sentence has been imposed because Mr. Dixon does have the right to withdraw his guilty plea up and until the time of the sentence.
Okay, then let's get an update on how long it's going to take to get folks here.
Yes.
And we'll see. I'll leave them for right now, but if there's a delay,
I understand.
I'll make them sit around.
And we may be able to have him appear via Zoom.
Okay.
Sorry, Judge, I was speaking to someone about the rest of, you said when this bill comes back, you do or you not put the jurors out?
I do, but the state has asked that we hold off on doing that. I understand why. So we're going to do a little more waiting to see if they can get the other victim here. And we'll see. I don't want to leave those folks in there too much longer. Yeah, just let them know that the lawyers and the judge are working through something and we'll get them out here as soon as possible. Thank you.
All right, Judge, we're good.
You soothed them. They've got their box of snacks too.
Yeah, I think everybody thinks.
Okay, thank you.
My pleasure.
Your Honor,
Mr. Shapiro,
we will have one of our victims appear shortly on Zoom and the other has a prepared written statement that one of our victim advocates can read to the court.
great. Okay. So meaning it's probably Ms. Jones, I think. Ms. Jones will appear via Zoom and then Ms. Edwards-Holland has something in writing that, okay. And that you feel is sufficiently accommodating the desires of the victims in this case.
Yes.
In other words, Ms. Edwards-Holland's not going to show up tomorrow fussing about why did I not get to come to court?
Miss Edward Hollins is present. She's right outside.
Oh.
She understands what we're doing this morning. She's expressed a desire to have the victim advocate read a statement on her behalf rather than.
Understand much better. And then Ms. Jones is here.
Ms. Jones is not here. She was going to be called later this afternoon, hence why she's not here yet, but she can appear via Zoom. I see that she's actually already on.
Excellent. Okay. Then are we good
If I
or?
could just have one moment.
Sure, just let me know. That's much faster, so you can have 2 moments.
Thank you, Judge.
Did Ms. Wood go back with Mr. Dixon?
Yes.
Okay, no, they're good. They're good until Shapiro says yes. Let's not drag everyone out here. 2.5.
That's fine. Yeah, fine. Mhm.
Ms. Wood, we're actually going to get started in just a couple minutes. So we'll get Mr. Dixon out here in just a sec, once Mr. Shapiro says he's ready.
Grandmother. I thought it was me to walk in. Yeah. Yeah, sure. Judge, I don't know if there was an update while Ms. Primovic was standing in place about the other 3 cases.
No update.
Okay, I was just trying to advise Mr. Dixon.
And I'm not requiring it to happen. Well, I want something to happen with the SC case. The CP cases will go wherever, but they won't go wherever. They'll come here if we don't take care of the drug case. So I hope you'd be authorized to, I have it up here. We can look at it, but it seems like the kind of thing that could go away.
I can't imagine that anyone's going to have any issue with me dismissing those, Judge.
Okay.
So do I have time to pop back here? Really quickly?
Sure. When Ms. Wood comes out, can we get going, Mr. Shapiro?
We can, Judge.
I don't think it merges, but we'll get that on the record. We're ready for him, please. All right, Ms. Fuse, are you ready?
Yes.
Great. We're going to go back on the record in State versus Dixon. We took a brief break. The district attorney's office was lining up the two victims in this case, Ms. Jones and Ms. Edwards-Holland. It's my understanding, Mr. Shapiro, that Ms. Jones is going to appear virtually on a screen.
Yes, Judge.
And then Ms. Edwards-Holland will be heard through a written statement she prepared that a victim witness advocate will be reading into the record.
Yes, Judge.
Got it. Okay. Then I'm going to turn it over to you to make your sentencing presentation as you see fit. And then I will hear from Ms. Wood on behalf of Mr. Dixon. And Mr. Dixon, you'll have a chance to say something too. You don't have to say anything at all, but I don't want you to be surprised if after I hear from the state and I hear from your lawyer, I say, Mr. Dixon, you've got a right to be heard as well. You do, but you can do all your talking through Ms. Wood. But know that I'm going to ask you, I'm required to ask you, so that if there's something that you want me to hear, I do hear it before I say, here's your sentence. Okay? All right. Mr. Shapiro.
So, Judge, I won't repeat the very general fact basis, as the court is now aware. Mr. Dixon has pled guilty to 8 offenses that all arise from a shooting incident, in which Mr. Dixon appeared at a property where the car that the 2 victims were driving in, Mr. Dixon parked his car, making it impossible for them to leave, locked them in, and then was heard saying, "You think I won't kill you, bitch," before discharging a single shot. That shot struck the windshield of the vehicle and ultimately struck one of the victims, Ms. Jones, in the face. As I said, both of the victims identified Mr. Dixon as the shooter while at Brady Memorial Hospital. The state, in speaking to both of the victims in this case, initially requested more time because what has been discovered in discussing the facts leading to this shooting was that this case is really about a domestic violence relationship between Mr. Dixon and Ms. Leah Edwards-Holland, in which terrible abuse was perpetrated on Ms. Edwards-Holland. And that abuse ultimately led her, even after her friend Janiyah Jones was shot, to return to Mr. Dixon. And Ms. Edwards-Holland was fully prepared to come into court today to testify to that, to testify to the fact that even following the shooting, she returned to Mr. Dixon. She is not from Georgia originally. She's a native of California. She moved here with no support from family members and was essentially homeless before falling into this abusive relationship with Mr. Dixon. Because of that lack of support and because she felt she had no other options, she returned to Mr. Dixon, where Mr. Dixon continued to threaten violence against her in order to coerce her into giving a false statement to police officers. Ms. Edwards-Holland.
In connection with this.
In connection with this shooting, Judge. Ms. Edwards-Holland met with the lead investigator, Ronald Whaley. Investigator Whaley was prepared to come in and testify that originally she identified the shooter as someone named Demarion Williams and was shown a photo of Mr. Dixon, stated that she didn't recognize him, was not familiar with him, didn't know him. Almost immediately, as she's being led out of APD headquarters, she recants that statement and explains to the lead investigator that she lives in fear for her life from Mr. Dixon based on the cycle of domestic abuse. And this abuse involved, from what we understand from Ms. Edwards-Holland, binding of her hands and feet, loading a revolver with a single round and playing Russian roulette, beating her to the point that she miscarried her unborn child only weeks before this incident. That is what Ms. Edwards-Holland was prepared to come in and testify about. She immediately recanted her statement to Investigator Whaley, explained that because of all those incidents, she lives in fear of Mr. Dixon.
She recanted her initial statement that it was Demarion Williams, not that she recanted the, you know what, actually I've been abused and it's because of that I didn't want to tell you who did it.
Yes, Judge.
Okay.
And she ultimately was provided a photo of Mr. Dixon, which she signed, identifying him as the person connected with the shooting. APD, in an effort to shield Ms. Edwards-Holland from any further abuse, arranged for her to be placed in a hotel room in Alpharetta. Mr. Dixon, again, came to the hotel room where Lee Edwards-Holland was staying. Speaking with Ms. Edwards-Holland, she states.
So this is just in this window between July 5th and I think you said July 12th.
This is in between the window of July 10th when she gives the statement to Investigator Whaley and July 12th when Mr.
Dixon's finally arrested. Okay.
Ms. Edwards-Holland states that Mr. Dixon came to the hotel room, immediately entered, headbutted her, took her phone from her so she was unable to have any more contact with the investigators. Ultimately, Ms. Edwards-Holland had to escape the hotel room in order to contact the police. That is how Mr. Dixon was apprehended. So surrounding the even initial shooting, there's this whole story of the domestic violence relationship between Mr. Dixon and Ms. Edwards-Holland.
So
that's to say,
keep going.
That's to say, Judge, nothing of just the actual injury to Janiyah Jones, who's the juvenile in this case. And the two exhibits that I do want to show to the court in connection with the sentencing is a photo of the injury to Ms. Jones at the time that she is taken to Grady Hospital. She's taken to Grady Hospital where the emergency trauma surgeons observe that there's an initial entry wound to the left side of her chin. There's also wounds that could be from either the breaking of the ballistic itself or from blast from the windshield of the vehicle, around her chest, under her clavicle. Radiologists, when they take scans of Mrs. Jones, discover that the bullet is still lodged in her neck. That this is not an entry and exit wound. She has found the bullet still lodged in her neck. In speaking with the radiologist who would have testified in this case, she describes that this bullet was mere centimeters away from carotid arteries, veins, nerves, any of which, if damaged, could have immediately caused Janiyah Jones, a 16-year-old girl, to bleed out on that scene and die. It is nothing short of a miracle that this bullet came to rest where it did, avoiding all of those major organs, avoiding her spine, avoiding her esophagus, avoiding those nerves, avoiding all of the veins that could have caused her to bleed out at the scene. And the state, meeting with Ms. Jones, who's going to appear in just a moment, Ms. Jones is able to demonstrate on her neck where that bullet is still lodged to this day. She's able to describe the metallic taste that she had for weeks afterwards as gunpowder was leaching from this projectile. She will live with this injury for the rest of her life.
So the doctors have said trying to remove it is more dangerous than the risk that it poses by leaving it in.
The risk of potentially removing it could cause further damage. That's exactly right. It's simply not worth the risk as long as it is what they have described as in a state of stasis. that removing it may cause further damage. So surrounding what is just based on the simple fact pattern that I provided the court, a simple shooting is a lifelong injury to a 16-year-old child and traumatic abuse that was perpetrated on this other victim. And so, Judge, with that, I want to give Ms. Jones and Ms. Edwards-Holland the opportunity to address the court.
Sure. Before you do that, my question was, but I had started to interrupt you. I think I heard you say, based on the things I'm about to tell you, Judge, the history of abuse that Ms. Edwards-Holland went through, and then the severity of Ms. Jones' situation and the closeness to death that we're talking about, that the state was recommending more. But then there was 8 and then there's 15. I'm just trying to understand what was more and why the transitions to something much less, 8 and now almost double 8, but maybe still less than what the initial recommendation was.
Judge, as I believe we were clear with defense counsel and the court at the time the offer was extended, because of the circumstances that I've described surrounding Ms. Edwards-Holland and some that I have not described surrounding Ms. Jones, there are other factors at play here, including housing insecurity, other issues that frankly I don't want to put on the record because it's no one's business but the victims. However, at the time the offer was extended, the state essentially had no contact with either of these victims. But given the factual basis, given Mr. Dixon's pending matters, the state extended what it felt was a more than fair offer in an effort to resolve it without the need to cause more trauma to these victims by having them come in and testify.
Okay.
And I understand that the argument is typically that by entering a plea, our victims have been spared from a trial. Certainly they've been spared from the aspect of coming in and testifying to a jury, but make no mistake that every time we have to meet with a victim to re-interview them, that causes additional trauma. Reliving these experiences re-traumatizes these victims. So because of that, the state has increased its offer. I think that ultimately what we feel is that the recommendation reflects the serious nature of these offenses without, again, causing the victims further trauma by having to come in and testify in a trial.
Got it. Okay. That makes, I wasn't criticizing, I was trying to understand the evolution of all that. And I trust that your team has discussed with Ms. Jones and with Ms. Edwards-Holland these figures as well. And they'll be free to share with me their perspective on it, but this isn't news to them.
Judge, the state's complied with its obligations under the law to communicate all of this to the victims.
Okay. If you don't mind taking the image down, then I'm happy to hear from Ms. Jones through Zoom or the statement from Ms. Edwards-Holland, whatever order you want to go in.
I see that Ms. Jones is on the Zoom. And so Ms. Jones, I'm just going to ask you to unmute yourself so the judge can hear you.
Yes, we're here.
And Judge, for the court's benefit, that's Letitia Jones. That's Ms. Janiyah Jones' mother.
Okay. Hello, Ms. Jones. I'm Judge McBurney. I'm doing okay. It's a difficult time right now for a lot of folks. Is your daughter there and does she want to say something or do you want to say something on her behalf?
I'm gonna you need to speak from your standpoint. I'm gonna let her speak.
Okay. Ms. Jones, there isn't anything you have to say if you're not comfortable doing that, but if there's anything you think I should know about what I ought to do in this situation, I'm happy to hear from you, okay?
Okay. I think he should stay in jail because it is in my neck and I do gotta deal with it for the rest of my life. And I was still young and it put my life in danger. I'm glad it didn't hit nothing though, and I didn't bleed out. And yeah.
Okay. Well, we're glad that you didn't bleed out either. You are a miracle kid that it stopped where it stopped. And I'm glad you are doing better. But to Mr. Shapiro's point, this is something you're going to live with forever. And it's got to be very traumatic. Are you in a better space now? Are you connected with your mom again? What's going on with you?
Yes, I ended up coming back home with my mom after I got out the hospital, and we've been better since then. And I just healed from there.
Good. Are you trying to go back to school? Are you going to do some work, or what are your plans?
I do school at home. I'm too traumatized to go anywhere.
Okay. So you do stuff online?
Mm-hmm.
Okay. Well, Ms. Jones, I appreciate you sharing that. Is there anything else you want me to know?
No.
All right. Well, good luck to you. You're a survivor. Thank you. And ma'am, is there anything you want to add on behalf of your daughter, or she said it?
Pretty much. I feel like he deserved the max amount of time. Because I know if he get out, it could possibly be done again. And you know, of course, he was already a felon and all that stuff. So yes, I wouldn't even feel comfortable with him walking the streets again.
Okay. Well, I understand that perspective. Thank you, Ms. Jones.
Okay.
Okay, Mr. Shapiro, tell me how you want to proceed with Ms. Edwards-Holland's statement.
Judge, Kristen Clark is an advocate with the district attorney's office. She has a written statement that Ms. Edwards-Holland is prepared to have read to the court.
Great. Ms. Clark, we don't have a court reporter in the courtroom, so I need you to be near a microphone to share Ms. Edwards-Holland's statement, please.
Good morning, Judge.
Good morning.
My name is Kristen Clark. For the record, it's spelled Christen, last name Clark, Clarke. I will be reading a statement on behalf of Relia Holland. Her statement says, I, Relia Holland, would like to make a statement about how DeMarcus Dixon has negatively impacted my life. Before I met DeMarcus, I was very confident and very driven to do stuff. Since my relationship with DeMarcus, I've struggled with so much anxiety, paranoia, and fear. He took advantage of the fact that I was young and manipulated me at a very vulnerable stage in my life. He made me feel weak. He got into my head and made me feel like everything was my fault. He controlled me and made me feel like I couldn't do anything on my own. He would take my phone. He would follow me when I left the house. He made me feel like I wasn't worthy and couldn't do anything by myself. He made me feel like I needed him. Today, I am working through my trauma regarding this incident.
How old is Ms. Edwards-Holland now? 18. And she knew Mr. Dixon for a couple years, 3. I'm wondering how young she was when they first met.
She was 18.
Okay, so it's all been within the span of a year that this happened. Okay, thank you. I appreciate that.
Thank you.
Judge, the last thing that I will say with respect to the sentencing is that the state, in preparing for this trial, has continued to monitor Mr. Dixon's conversations while housed at the Fulton County Jail. And from the information that we've obtained, that we've of course provided to Mr. Dixon's counsel, it appears that this cycle in which he thinks he can continue to influence and manipulate the women surrounding him has continued. I've provided with Ms. Wood a call in which Mr. Dixon is recorded stating that the witness that he intends to call needs to be prepared to be in court and needs to be prepared to testify, to put herself on the scene and put someone else on the scene committing this shooting. I also observed Mr. Dixon, as I'm sure the court did as well, during voir dire in this case. And I understand that the court likes to strike a certain tone in order to make jurors feel more comfortable, and I appreciate that. But I was struck by the fact that as we are sitting there trying to pick jurors who are going to make a determination in this case in which a 16-year-old was shot, that Mr. Dixon is sitting there smiling and laughing. The impression to the state from the outset of this is that this is a game to him. He is continuing to try to evade responsibility up to and until the point when the evidence is simply so overwhelming that he cannot escape it. And so for that reason, Judge, we are asking that you accept the state's recommendation of 25 years to serve 15 in custody with the balance on probation.
All right. Thank you, Mr. Shapiro. I appreciate that. Ms. Wood. Oh, before I hear from Ms. Wood, what is happening with the 22 SC 185350 and the 2 unindicted cases.
Judge, the state will be entering a dismissal in any pending matters.
Okay, so we'll get through all this, assuming we get through all of it, and I impose a sentence. Then the 22 SC would be null prost and the 2 CPs would be
Decline, Judge.
declined. Okay, I just want to make sure if there's going to be complete closure, we know what that is. And it sounds like, Mr. Dixon, after I sentence you in this case, the state is going to dismiss the other cases, that none of which is as serious as this one. And so that'll be how we resolve all of those matters. We didn't get, we have Ms. Tucson on, which is great. I got Mr. Dixon's criminal history back when this was maybe going to be a plea. Just so we've got that. It was 18 cycles. The most recent arrest was in June of 22, not reflecting the arrest in this case. And that relates to the theft by receiving, I think, CP matter that's out there. There may be a hold from East Point. We'll clear that up. I don't know that there are any prior felonies. There was a NOLO misdemeanor out of Clayton County and then disorderly conduct out of Baldwin. Ms. Tucson, thank you for joining us. Do you have any adult felony criminal history for Mr. Dixon?
Good morning, Judge. From everything that I pulled up, he does not. Doesn't show that there's any active probation, and he's not coming up in portal at the moment.
Okay.
Unless there's a different name or alias or information, but no, not as
Okay,
that's information I have.
Thank you. That's consistent with what pretrial services shared last week. Mr. Shapiro, do you have anything different?
No, Judge.
All right, Ms. Wood.
Thank you, Judge. First, I just want to point out that Mr. Dixon is accepting responsibility, already has accepted responsibility since we've done the guilt portion of this, and this is the sentencing. He has been in custody 281 days, so he was arrested on July the 13th of 2022. We would ask that he get credit for all of that time, Your Honor. He's 29 years old. He was 28 at the time of the incident. He grew up here in Atlanta. He's a Grady baby. He grew up with his grandmother, Patricia, who is here present in support of DeMarcus. He has other family in support. I know his mother was going to be here. I know she's running late, so I'm not sure if she made it in or not, but I have had contact with her and Miss Patricia throughout. He has 2 children, Judge. He has a 3-year-old and an 8-year-old, Kason and Journey. He is a South Atlanta high school graduate, and he has 2 years of a college education. Prior to his arrest, he was gainfully employed with a furniture company. He did moving work for them, Judge. Judge, as he has accepted responsibility, we would, I'm sure you gathered from the motion in limine that I filed yesterday, we would be disputing some of the evidence that Mr. Shapiro brought up about domestic violence accusations. Mr. Dixon did ask me to make sure that was clear to the court in considering a sentence. There are some mental health struggles, as he discussed with you previously, depression and anxiety. And also there was mention in discovery of drugs being involved. He has informed me that he has struggled with some drug addiction since 2018. We are hopeful that during his service, he will be able to avail himself of the programs that are offered through the Department of Corrections and seek treatment for mental health issues as well as drug addiction, Judge. Other than that, we are asking that you take into consideration that he is admitting guilt and taking responsibility for these charges. And Judge, I do want to apologize to the court. We did recommend the sentence of 20 serve 8. In the back, Mr. Dixon asked me to alter that request and ask the court to consider a sentence of 20 serve 3. So I'm making that request on his behalf.
Mhm.
And finally, we also went over the benefits and then the pros and cons of being sentenced as a first offender. And Mr. Dixon is asking the court to consider a first offender sentence, Judge.
Got it. Okay. Thank you. Mr. Dixon, we've reached that point that I forecast for you. Is there anything you want to say to me? If you do, I'm happy to hear it, but you're talking to me, not anyone in the courtroom, no one on the screen. Judge, this is what I want to tell you. If there's anything you want to add to what Ms. Wood shared with me.
You don't have to say anything.
You don't have to say anything at all. You can say anything you want. We're past the point where your lawyer is going to say, oh, don't talk about the facts of the case. If there's something you want to tell me that you think I ought to know before I impose sentence, I'm happy to hear that, but I don't hold it against the defendant who doesn't have anything to say.
Just, I feel, I'm sympathetic about what happened to the young lady in the case. Like, I really hate that anything ever happened to her, period. Like, literally, like, I'm not as bad as people try to make me out to be. So I'm saying, like, I'm never been convicted of a felony. I don't even go to jail. I just want to get this part of my life out of the way.
Okay. I can understand that. Mr. Dixon, I've already found that your plea is knowing and voluntary and that there's a factual basis for it. So we're going to turn to sentencing now. I'm going to get the technical piece out of the way. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that the part of your sentence that's on probation, because at some point you're going to be on probation, if you have a small violation, you and probation will manage that. But if it's a serious violation, you get arrested again, or there's any evidence that you tried to contact Ms. Jones and her family or Ms. Edwards-Holland, that would be the type of violation that comes back to me. And if it is substantiated, if it's proven, I'm going to revoke a whole bunch of your probation, because those are important conditions that are meant to allow Ms. Jones and Ms. Edwards-Holland to go in the direction they need to go, and for you to go in a very different direction. Mr. Shapiro, if I look at the indictment here, I think that count 2 would merge into count 1. That's the aggravated assault on Ms. Jones, and I'm saying it in reverse order. Count 1 is the aggravated battery on Ms. Jones. Count 2 is the aggravated assault. I believe those two merge. I don't think anything else merges here. What's your thought on that?
That the state agrees, Judge. Counts 1 and 2 would merge.
Okay, and tell me what you think the sentencing range is for counts 7 and 8.
So, Judge, counts 7 and 8, as the court is aware, have to be served consecutive to any of the underlying felonies, and believe that the sentencing range.
My thought is there's 0 to 5 and they can run concurrently with each other, but they have to be consecutive to whatever the highest count is.
They can run concurrently to each other and must be consecutive to the predicate felony.
Okay, and must be 5 years, probated, suspended, or time served.
5 years.
Okay. That's the way I intend to structure the sentence, Ms. Wood. Do you have a different view about merger or how it needs to work?
No, Your Honor, that sounds correct to us.
Okay. And I know I've already asked, I must have missed this when you were describing it. The range for cruelty to children in the first degree
Is 5 to 20 years, Judge.
5 to 20. And then the terroristic threats is 1 to 5 or 1 to 10?
1 to 5, Judge.
Okay. And it's not a family violence, aggravated assault, or aggravated battery as to Ms. Jones, because that was stranger on stranger, and the state did not allege the aggravated assault on Ms. Edwards-Holland to be a family violence one. Okay. All right, Mr. Dixon, I appreciate the work Ms. Wood has done on your behalf, and I also appreciate your desire to get this behind you. That's easier said than done, in particular for Ms. Jones and Ms. Edwards-Holland. We know Ms. Jones will never forget this because she's got a bullet in her neck that you put there. And it sounds like from everything I've heard about Ms. Edwards-Holland that while she was spared being physically injured by the gunshot into the car, she will carry with her emotional trauma and maybe some physical difficulties for the rest of her life because of the relationship that the two of you had. I want to be clear, the sentence I'm imposing is based on the facts of this case. It was helpful to hear from Mr. Shapiro that your relationship with Ms. Edwards-Holland had not been healthy, had been abusive, and the jury would have heard some about that, I suspect, so that they could better understand why Ms. Edwards-Holland would have initially told the police when they held up a picture to say, hey, do you know who this is? I don't even recognize that guy. When in fact, it was her alleged boyfriend of about a year. So that gives me context as to the type of relationship it was and how you were treating her. Frankly, it helps me understand better why you'd pull out a gun and fire into a car that she was driving. Otherwise, in some ways, it doesn't make sense anyway, but at least it helps me understand that might be how you were used to interacting with Ms. Edwards-Holland when she did something that upset you or displeased you. But your sentence in this case is driven by the facts to which you've admitted. You didn't admit to all the stuff before July 5th. You've admitted to saying what you said, pulling out the gun and firing the shot. And while the luckiest person in all of this instance is Ms. Jones, in the sense that she didn't die, you are pretty lucky because we're talking about sentences that are involve numbers rather than the word life. Because if that bullet had been a fraction of an inch in any other direction, we'd be talking about life, maybe life without parole, because of what you did. And so I'm grateful Ms. Jones is alive. You should be grateful that your sentence has an end date to it, as opposed to you go to jail and you die in jail. That is something that you were facing briefly because of your decision to point that gun and pull that trigger. And there's really not a way to justify or explain any of what happened on July 5th. Mr. Dixon, on count, let me make sure I'm structuring this the right way. On count 1, I'm sentencing you to 18 years to serve. Count 2 merges into count 1. Count 3 is 15 years to serve. It will run concurrently with count 1. Counts 3 and 4 are both 5 years. They will be probated. They will be consecutive to count 1 and concurrent with each other. Count 6 is 15 years to serve. It will run concurrently with count 1. And count 7 and 8 are both 5 years to serve. They are probated also. They will run concurrently with each other, but consecutive to count 4, which should create a sentence of 28 years to serve 18 years with the balance on probation. You will get credit for all the time you've served. I will note that these are parolable offenses, so you will be eligible for parole. Parole is not a decision that I make. I am not involved in that process. The Board of Pardons and Paroles will handle that. It will be a special condition of your probation, Mr. Dixon, that you submit to a mental health evaluation upon your release. And if that medical professional recommends any treatment, you will be required to follow that treatment as part of your probation. The other 2 special conditions of your probation are, number 1, no contact, direct or indirect, with Ms. Jones or her family. And 2, no contact, direct or indirect, with Ms. Edwards-Holland and anyone who, by the time you're released, is part of her family. I will waive your probation supervision fees for the first 6 months after you are released, so that you can get back up on your feet and start working, whether it's as a furniture mover or maybe while you are in custody, you're going to learn other trades and practice another line of work when you are released. Mr. Shapiro, is there anything else you need me to say in connection with this plea?
Nothing from the state judge.
Ms. Wood?
No, you're not.
Okay, thank you. So we're gonna let these, when you're ready, take your time. So we let the first group leave, and then we're gonna let Mr. Dixon's family and friends leave. Then we'll bring the jurors out and let them know what happened. Thank you. Thank you, Ms. Wood, for working with Mr. Dixon and getting him what I believe is the best possible outcome.
Thank you, Judge.
Oh, so Mr. Shapiro, let's get this on the record as well. Ms. Fuse, this will be the last bit of the record. I'll excuse the jurors off the record. Mr. Shapiro, are you moving to null pros 22 SC 185350?
The state is moving to null pros that case, Your Honor.
Okay, Ms. Nelson will take care of that. And I'm gonna leave it to your office to handle the CP cases.
We'll be submitting it to my judge.
Okay, thank you, Mr. Shapiro, and Ms. Lugo, for your work on Mr. Dixon's case. What was the issue? You had to have someone leave for a minute. What was going on? You did that very discreetly, but what was the issue?
They were just getting a little too loud for my liking in the courtroom, so I asked her if she could quiet down for, the sake of the courtroom.
Yeah.
She proceeded to tell me that she was gonna call Sheriff Levi, and she was the one that got her Victor Hill.
Oh,
Took her on the hallway. I said, "You're more than welcome to come back in if you can remain quiet
Right.
while we're proceeding." She told me she was leaving.
but she came back and showed you a little piece of paper.
She wanted me to know exactly who she was and that Sheriff Levi would be calling her shortly. I
Okay.
have yet to receive that call.
Okay, let me know.
So yeah.
Thank you for managing that.
Oh, my pleasure. You ready for the jurors?
Yes, if things are under control out there, let's bring the jurors in, please.
Oh, okay.
No, we can wait so they're all ready. No pressure on the restroom user.
It won't take that long, I promise.
Yeah, we're standing for you. You take a seat in whatever seat you grab. And Ms. Burse, you take the seat that works best for you. Everyone else is going to move for you. Good morning, ladies and gentlemen.
Good morning.
Welcome back to 8D. I understand one of you got stuck on a bus with someone unruly on the bus, and I know there was crazy traffic. Something real bad happened on I-20, and so traffic was tricky, but you guys made it down here, and I appreciate that. You also sat around for a whole lot. Normally, we don't do that at the beginning of a trial, and I was all prepared to give you the opening instructions about your responsibility and the lawyer's responsibility and how a trial is going to work. And then these lawyers were going to give you opening statements, their forecast of what the evidence would be, and then we get going with the state's first witness. But because you were here and really focusing Mr. Dixon's attention on what his options were, while you were back there, hopefully enjoying the snacks and the K-cups, Mr. Dixon elected to enter a plea to all counts, and I just sentenced him to 18 years to serve. He was in an abusive relationship, the abuser of the abusee, and what you would have heard about was that on the day in question, which was July of last year, he pulled in to a parking lot and blocked in a vehicle that his girlfriend was driving, and she had a passenger in the front seat. And Mr. Dixon got out, said some threatening things, as the terrorist do. Deputy Gordon, jurors are happy to see you. Those are the clothes Mr. Dixon was wearing. Said some threatening things and fired one shot through the windshield. That shot entered not the girlfriend, but the front seat passenger's chin and lodged here in her neck. And you would have heard from doctors that a few millimeters this way, dead. A few millimeters this way, paralyzed. She's alive and well and as healthy as you could hope. I actually got to hear from her via Zoom as she shared with me how this has affected her and what she thought ought to happen to Mr. Dixon, which is how we handle sentencings. Once Mr. Dixon pled guilty, it's important that I hear from the victims. I heard from the girlfriend, the former girlfriend as well, through a victim witness advocate. And I heard from Mr. Dixon's attorney, Ms. Wood, and ultimately Mr. Dixon. And have accepted the guilty plea, entered the sentence, and the case is over. There's not an appeal. There's not a trial where these two young ladies have to come in front of you, strangers, nice strangers, but strangers nonetheless, to talk about what they went through. So I want to thank you for your service. The lawyers thank you. Again, but for you, this wouldn't have happened. Mr. Dixon has the presumption of innocence in his favor. It's not his job to prove anything. These lawyers have to do it. Both of the victims in this case were working through some economic challenges and weren't real easy to find. And so a couple of weeks ago, if we had to go to trial, the state might have had to say we had to dismiss some charges because we can't find one of the two young ladies, but they did catch up with everyone. And the defense had an opportunity to talk to witnesses and listen to some jail phone calls Mr. Dixon had made. And in the end, he made what I think was a pretty wise decision to say, let's cut our losses and enter a plea and not have the jury hear about all this. So your service is complete. In a few moments, you can leave. You don't have to have heard about all this or see any of the pictures that I saw about the injuries. You don't need to go back to work today. You're welcome to, but just like on Monday, I'm not going to tell anyone that jury service ended early. This was your day of jury service. If anyone needs a letter, we can generate a letter that is on my letterhead that says you were here on Monday and today. If you don't need that, well, they're right there. You can have one anyway. You can frame it and hold on to it. We didn't mean to inconvenience you this morning, but it took a while. This plea had a lot of moving parts, and one of the two victims wasn't going to be here till this afternoon. And so we had to get her connected via Zoom. And frankly, Mr. Dixon had to do some thinking. We got partway through and he needed a timeout. He advocated, unsurprisingly, for a lower sentence. But it's my decision in the end, hearing about his situation. He hadn't had a great life either. But that doesn't justify what happened here. It helps explain how people might think this was a way to resolve a dispute. But it doesn't in any way minimize what Ms. Jones, who's the person who got shot, and Ms. Edwards-Holland, who is the former girlfriend, what they went through. So in a nutshell, kind of big nutshell, that's what we've been doing this morning. That's what you would have heard about over the course of the next 2 days in a much more personal and graphic way than I did. It was through Mr. Shapiro mostly, as he summarized what the evidence would be. But they would have brought the officers and the victims and the eyewitnesses in, and you would have processed all that. So I appreciate you all being here. If you have any questions about anything I just described or what's next, now's the time to ask. Otherwise, Deputy Gordon can get you those letters and you can be on your way. All right. Well, thank you so much. You can take those notepads back, leave them there on the table, and Deputy Gordon will get you safely out of the building. Okay. Yeah, that's good. That's his usual thing. Ms. Burst, I appreciate your willingness to serve. You have slightly more complexity navigating everything here, and you're a dynamo for doing it. Thank you. All right. Anything else, Mr. Shapiro?
Nothing from the state, Judge.
Ms. Wood?
No, Your Honor.
All right. Thank you all. I may drift down to 1D to see Mr. Jordan in action. We'll see. I think that's it, sadly, for the week. I will see you guys Monday. We've got some stuff. Ms. McCauley, this isn't quite in your wheelhouse, but Mr. Jordan has said he's leaving as of May 15th. We have a trial calendar that starts May 15th. And so if you could just share with his supervisor that he's going to have some cases on there. They'll need to be ready to go. I'll work with either him or the incoming person so that that person doesn't need to be ready on a ton. But the DA's office election to rotate folks the day a trial calendar starts would be the your problem, not my problem kind of thing.
I could be there and we'll communicate that, and actually Mr. Shapiro and I approach after all of this.
Yes.
To talk about another issue.
Fantastic. All right. Ms. Fuse, thank you so much. Do you need anything else from us, or you will work through with our court admin folks to take care of things?
Yes, I'll work with the court admin folks to finish up.
Okay, great. That's it. So if you were going to be covering the rest of the trial, you get an early into your week.
Okay, thank you.
Thank you. Bye-bye.
Bye.
Thanks, Ms. Tucson, for plugging in.